Good afternoon, everyone. Welcome to the Permitting Division's Treated Wood Waste Variances webinar. Next slide, please. Today, we're going to talk about the overview of the variances. We're going to take your questions and discuss key concepts and discuss the variance application and process for a variety of situations. I'd like to welcome Rizgar Ghazi, Deputy Director of our Hazardous Waste Management Program. Rizgar.
Good afternoon, everyone, and thank you for joining. My name is Rizgar Ghazi. I'm the Deputy Director for the Hazardous Waste Management Program. This is our second session we're having. Last week we had a webinar in regards to the variance application process and to support how you go about getting a variance from DTSC. We received a lot of comments last week, and we thought we'd have another one to address additional questions and some clarification that we weren't able to answer last week. Could you move on to the next slide, please? So tree wood waste, that variances, I want to give you an overview of what that is and why it's needed. So as you know, the law that allowed management of treated wood waste under alternative management standards subsided at the end of last year. And as you know, treated wood waste is considered hazardous waste and it needs to be managed as a hazardous waste. There were regulations that went along with the law as well sunsetted and went away. So now the only way you can manage hazardous waste, the treated wood waste, is managing this waste. DTSC, in consultation with the industry members, internally within DTSC and the governor's office, we were proposing to issue variances for management of the treated wood waste under the alternative management standards as there were before. However, it requires the department, the applicants, to fill in an application and to request for a variance, and that's a process we talked about last week. And in the next slides, Mr. Ryan Betty, or supervisor for the permitting program, will walk you through the application process. And with that, could you move on to the next slide? Okay, so again, last week we presented to you the variance application process, and we opened it up for the landfills to apply for it. I understand we have many landfills already applied for the variance, and we're processing those applications. I hear a phone call. I'm not sure why. Just to let you know that the variance application is being processed at the landfills, and today, after today's presentation, the variance application will be opened up for all applicants would want to get a variance from us. Again, this is an interim measure to address the management of treated wood waste until the legislature puts a new a new law bill gets through, and to address the proper management of treated wood waste. Please move on to the next slide. So I'll introduce Ryan Betty. He's our supervisor. He'll walk you through the permit application process. Thank you.
Thank you, Rizgar. Good afternoon, everybody. My name is Ryan Betty, and I'm a supervising engineer in the permitting division at DTSC. Next slide, please. So as Rizgar mentioned, we had a webinar last week, which was very well attended. We had a number of questions asked at that webinar, which is part of the reason we are having this additional webinar today. Just so you know, if you'd like to take a look at the slides from the last webinar, they are being posted to our website today. And we will also post the slides that we're presenting today to the website as well. So the focus of this webinar, many of the slides are the same as we presented previously. However, we're going to drill down a little bit and discuss some common questions and topics that we received after the last webinar. We also want to provide some more information. We got a lot of questions from folks about how to determine which type of variance is appropriate for their situation. So we're going to talk about that. We're also going to go over some example scenarios, and then we're going to walk through the application process again like we did last week. And then finally, we're going to have opportunity for question and answer at the end. Next slide, please. So one of the questions that we received, a lot of questions, was regarding illegally dumped treated wood waste. And as we indicated at the last webinar, we have developed a FAQ response regarding illegally dumped treated wood, and that is going to be live on our website this afternoon. I'm just going to briefly discuss what that FAQ indicates, but you should go and take a look at that. It contains more detailed information, but essentially options for a governmental agency that is responding to illegally dumped treated wood waste. So one option is to manage it as a hazardous waste. So that would involve manifesting it and shipping it via a registered hazardous waste transporter. Another option is there's a regulatory provision relating to emergency response incident operations, and the reference to the regulation is indicated there. That process is also called a variance, but it's different from the treated wood waste variances that we're discussing today. That variance process could be applied to any hazardous waste, so it's not limited to treated wood waste. So if you're interested in that, you can find out more information by reading the regulations or also looking on our website. A third option for a governmental agency would be to apply for a treated wood waste transporter variance. So that option would allow for transportation from the point where the waste was illegally dumped directly to a disposal facility. And then the fourth option that we identified would be if the governmental agency wanted to apply for a generator variance that would allow them to pick up the treated wood from, say, the side of the road, transport it back to a place such as a maintenance yard or some other facility that agency operates, and then from that point it could be transported to an appropriate disposal facility. So if you're interested in this topic, I would encourage you to go to the website and take a look at the full FAQ response. Next slide, please. Okay, so we got a lot of just general questions about the applicability of variances, so wanted to just address those. So a lot of questions about what types of treated wood are hazardous. So, you know, the regulatory structure in California is the generator is responsible for making a hazardous waste determination. And there's various different ways that you can do that. One is by applying generator knowledge. Another option is to perform analytical testing to establish whether it's hazardous. And, you know, what is, I think, commonly occurring in the case of treated wood waste is many generators are just making the assumption that it's hazardous because, you know, the time and expense involved in doing analytical testing may not make sense for them. So that's essentially the structure behind determining if it's a hazardous waste. Just wanted to clarify that. So these variances that we're discussing today, this is only for treated wood waste that is a California hazardous waste. So we sometimes use the term non-RCRA waste or state waste or California waste. So these variances apply to treated wood waste that is a non-RCRA California waste. So if, you know, and the information that we have is that in most cases, treated wood waste that you would see would qualify as a California hazardous waste. Another thing I wanted to reiterate is there's a separate provision of law relating to the management of treated wood that comes from utility operations. So, for example, power utility poles, etc. That's covered by a separate provision of law. It's the citation in the Health and Safety Code is indicated on the slide. So that exemption is still in effect. So if you're a utility and you're generating treated wood waste, you're still covered by that exemption and you would not need a variance. So hopefully that helps to clarify a few points. Next slide, please. Okay, also, we got a number of questions just asking for clarification on who's required to get a variance. So we just wanted to mention that applying for a variance is an optional thing. So if you If you have treated wood waste and you want to manage it as a hazardous waste, that's a perfectly valid way of approaching it. What we're doing by offering variances is to establish a process where, you know, there's a streamlined set of management requirements that would apply. And what we're trying to do is essentially replicate the status quo as it existed prior to the sunset of the treated wood alternative management standards. But if you want to manage it as a hazardous waste, that is a valid option. We also got a number of questions from generators who said, well, what if I want to show that my treated wood is not hazardous? So that is also a valid approach. If you, for example, if you're a large quantity generator, you generate significant quantities and you think that your particular waste is not hazardous, you can go through a process of demonstrating that. And I added a bullet here. It's important, if you're going to try and show that your treated wood is not hazardous, I would recommend that you closely communicate with the disposal facility, because it's important that they agree with your conclusion. So one way that this is commonly done is that someone who's wanting to dispose of a waste, you can create a waste profile, which is essentially between the generator and the disposal facility. You share information about the waste stream and mutually agree upon a profile for that waste. So that's one option if you want to try and establish that your treated wood is not hazardous. Next slide, please. Okay, we also got a lot of questions about who is the generator of treated wood waste. So I put a couple of from the regulations definition of what is a generator. So it means any person by site whose act or process produces hazardous waste, or whose act first causes a hazardous waste to become subject to regulation. And we also got question about contractors, especially that are involved in generating waste. So if you're hired to perform work and that work produces hazardous waste, both the hiring party and the contractor are considered generators, but either party can assume the duties of the generator. And that's what we commonly refer to as the concept of co-generators. Next slide, please. Okay, another question that we frequently got concerned who could be covered by a variance. And the context of many of those questions was, for example, somebody has an operation and they have a subcontractor or some sort of affiliate that works with them. And the question really related to, could that, you know, affiliate be covered by, you know, a variance obtained by the parent organization. So the way that we're responding to that is to refer you back to the language of the statute that we're issuing these variances under. So our variance authority extends to a site or sites owned by an individual or business concern. And business concern is a defined term in the Health and Safety Code. It means that any sole proprietorship, corporation, association, firm, partnership, trust, or other form of commercial organization. So when you apply, you should take that definition into account so that the appropriate entity applies for the variance. Next slide, please. Okay, for the next series of slides, what I'm going to do is just walk you through the steps in the process of applying for a variance. So what we've identified is 6 principal steps. And if you go to our website, it's also laid out in this fashion where there's 6 steps that you need to complete. So first of all, first step is determining if you require a variance and what type of variance. So next slide, please. So for purposes of this treated wood exercise, DTSC's identified 6 types of variance that we are offering. The 6 types are small quantity generator, self-transporter, large quantity generator, self-transporter, transporter only, handler transporter, disposal facility, and emergency response variance. So those are the 6 categories that we have identified as covering the majority of activities or management of treated wood waste. And I'm going to go through each of these individually and try and provide additional context to help you determine which would apply to your situation. Next slide, please. So first of all, I'm going to talk about the small quantity generator variance. So in order to qualify for this type of variance, you must be a generator of treated wood waste. You must have a fixed location, so like a street address where this generation is occurring, and you must generate less than 10,000 pounds per calendar year. So if you're applying for this type of variance, you must not transport treated wood waste generated by others. So you're allowed to generate your own, transport your own treated wood waste, but you cannot transport treated wood waste generated by others. You also cannot receive treated wood waste generated by others. Next slide, please. So the second type of variance we've identified as large quantity generator. So it's fairly similar to the small quantity generator. The key distinctions are large quantity means more than 10,000 pounds per calendar year. And in order to apply for a large quantity generator variance, you'll have to obtain a state or federal EPA ID number. So again, you cannot transport treated wood waste generated by others or receive treated wood waste generated by others. Next slide, please. So the next category we're going to discuss is the transporter variance. So as the name, pretty obvious, the intent behind here is strictly for those conducting transport operations. So essentially from the generator location to the authorized facility. So the authorized facility could be either a landfill or a transfer station. So if you're a transporter, if you have a transporter variance, you cannot act as the generator, cannot store treated wood waste, cannot consolidate treated wood waste, and you also should not be conducting treated wood waste management activities at a fixed location. So it's essentially just transport from the generator to an authorized facility. Next slide, please. So the last category I'm going to speak to in detail is handler transporter variance. So in order to qualify for this type of variance, waste management must be a principal function of your facility. You also must be authorized to operate pursuant to Division 30 of the Public Resources Code, and you must receive treated wood waste generated by others. And a handler transporter is not a disposal facility, so you cannot dispose of treated wood waste. So the other 2 categories of variance are disposal facility and emergency response. Disposal facility is we think is relatively straightforward and easy to understand, so we don't plan to speak to that in any significant detail. And also emergency response is a special category that we created. Currently, the only plan to utilize that emergency response variance category is to support debris removal from the wildfires that occurred in the latter part of 2020, but we've created it generally enough that it could be applied to some future emergency, but currently the plan for that emergency response variance is that it will apply to wildfire response activities. So next slide, please. Okay, so now the next series of slides, I'm going to go through some scenarios to help you understand which type of variance may apply to your situation. So this example scenario is an agriculture scenario. So if you may be a winery, you may be replacing treated wood grape stakes, and you want to transport that waste yourself for disposal. So in that kind of scenario, you would qualify as a generator, and whether you're a small quantity or large quantity generator would depend on the quantity of treated wood waste that you're generating. So if you're less than 10,000 pounds per calendar year, you'd be a small quantity generator. If you're greater than 10,000 pounds per calendar year, you'd be a large quantity generator. And just a reminder there that if you are a large quantity generator, you'll have to have a state or federal EPA ID number. Next slide, please. So the next scenario we're going to discuss is highway contractors. So we got a lot of questions from people that perform work, highway type work, either replacing guardrail or replacing signage or other activities for either counties or Caltrans. So it depends on who's the generator, but if the county or the owner of the roadway is the generator, then all you would need would be a transporter variance to be able to transport that waste from the point where it's generated to the disposal facility. So that would be the minimum you would need. And then a different scenario would be if the contractor is the generator, then you would be looking at potentially needing a generator variance. And I put large quantity generator there because I'm assuming if you're conducting this type of work, you probably would exceed 10,000 pounds per calendar year. So it depends on who the generator of the waste is. Next slide, please. So the next scenario I'm going to walk through is a residential contractor. So this scenario would be, for example, a fencing contractor or something similar to that. So in this scenario, what we expect would commonly happen is that the homeowner would be considered the generator. And there's actually provisions in our regulation that speak to treated or any hazardous waste that's generated incidental to owning and maintaining a place of residence. So I provided the regulatory citation there if you want to take a look at that. So that's the scenario. So contractor, doing work in a residential setting, the homeowner is the generator. So the contractor, if the contractor is transporting the treated wood for disposal, they would need at a minimum a transporter variance. And in the scenario where the homeowner is transporting the treated wood waste for disposal, obviously in that case, the contractor wouldn't need a variance because they'd be neither the generator or the transporter of the waste. So next slide, please. So the next scenario I'm going to walk through is a waste consolidation facility, essentially a transfer facility. So the facility accepts treated wood waste generated by others, consolidates the waste, and sends it to an authorized landfill for disposal. Provided that facility is authorized to operate by Division 30 of the Public Resources Code, a handler transporter variance would apply in that situation. If you're not authorized to operate by Division 30 of the Public Resources Code, you would not be eligible for this type of treated wood waste variance. Next slide, please. So hopefully that helps to walk you through some scenarios to help you understand how we envisage these variances being applied in the real world. So next, I'm going to talk about step 2 in the process, which is reviewing the variance language. Next slide, please. So we're going to be posting on our website sample variance documents. The idea behind doing that is to give you opportunity to see in advance of applying what type of document you're going to receive. You can read it over and make a decision if that makes sense for your situation, and also gives you opportunity to confirm you're willing and able to comply with the terms of the variance. The only comment we make is that these sample variances are probably very similar to what you're going to receive, but there is a possibility that on a case-by-case basis we may revise those sample variance documents to fit your specific situation or circumstance. Next slide, please. Oh, and just one other point regarding step 2. We're going to be posting all of the sample variance documents at the conclusion of the webinar. So currently just the disposal facility sample variance is posted, but later today all the variance types will be posted on the website. So the third step in the process is to prepare to complete the application. Next slide, please. So this step involves, what we've done is for each of the categories of variance, we've gone ahead and put a list of the questions on the website. So the idea here is that you can go and take a look at the questions in advance, and some of the questions may require you to do some research to gather the necessary information. So by providing the questions, the hope is that you can gather that information in advance. And that's important because the online application itself, you cannot save it halfway through. So you need to essentially have all the information ready to go when you complete the application. Next slide, please. Okay, so the fourth step is actually completing the online application. Next slide. So after you've gathered all the necessary information, you can click on the link that's linked to the application that's on our website. You'll follow the prompts and enter the required information, including which type of variance you're applying for. You'll then hit submit, and then you need to look out for, after you've submitted, you'll receive an email from DTSC. It's going to come from the email address indicated on the screen, which is tww_variances@dtsc.ca.gov. And if for some reason you don't receive an email from us, please contact us and we'll try and figure out what happened. Next slide, please. Okay, so next step is step 5, which is making a payment and signing and returning your application. Next slide, please. Okay, so after you've submitted your application, you'll receive an email from DTSC, and that email is going to contain, 3 key pieces of information. First of all, it's going to provide you with a unique variance application number, and I provided a sample number there. So it's going to be TWW-2021. The next 2 digits are going to be reflecting what type of variance it is. So LG, for example, or another 2-digit code reflecting what type of variance it is. And then the number on the end is just a unique number for your application. And we ask that you, anytime you're contacting DTSC regarding your variance application, if you can include this number, that will help us, associate the question with your application. So the email also will have all of the questions and responses, so all of your answers that you put in the application. And the third thing that will be in the email, it will calculate the reimbursement payment amount. And that's going to be a function of the type of variance you apply for and the number of locations covered by the variance. And just a quick point, so DTSC's, the statute that we issue variances under, we're required to recover our cost for processing variance applications. So that's the purpose for the reimbursement payment. Next slide, please. Okay, so after you receive the email and it's indicated the payment amount, you can go onto DTSC's website and make a payment electronically. So there's various different options for how to make a payment. If you want to receive your variance sooner, we would encourage you to make an electronic payment, like a credit card payment. That's the quickest way for us to verify receipt of the payment and allows us to begin processing it sooner. But there are other options available, and those are listed on the website. If you are making an online payment, again, we ask that you include the unique variance application number. And once you've made a payment, make a copy of the confirmation receipt that you receive. Next slide, please. Okay, so this slide is helping you understand how the reimbursement payment is calculated. So it consists of 2 parts. So there's like a base cost, and that's essentially covering the department's costs and setting up this variance process and developing the template documents and that kind of thing. The second part of the reimbursement payment is based on our actual time to review your responses in your application. And it varies depending on which type of variance you're applying for and also how many locations are covered by the variance. So I've done an example calculation here. So if you're applying for a small quantity generator self-transporter variance and it covers 2 locations, the reimbursement payment would be the base cost of $215 plus the, actually looks like there's an error in that calculation. It should say 2 times $757, which would be the cost per location, which would get you to a total cost of $1,700. So if you go onto the department's website after this webinar, there'll be a table which is indicating the reimbursement amounts for each type of variance so that you can take a look at that information, and it'll indicate what the cost is depending on the number of locations that are covered by the variance. Next slide, please. Okay, so this slide is just showing you what to expect when you go to the department's website to make a payment. So if you're paying by credit card, the green arrow is indicating there's a link for other DTSC payments. So that's what you would click on. Next slide, please. And then it'll take you to this screen, and then the green arrow, that's the box where you would put in your unique variance application number. So the TWW number, and then obviously the payment amount reflected in the email. Next slide, please. Okay, so the second part of step 5 is actually reviewing the responses. So the email will have, have all of the responses that you put in the application. So we ask that you read them over and make sure that they're correct. If there are any errors, you can correct it by hand. You'll then need to sign the application, scan it, and send it back to DTSC by email. If you don't have access to a scanner, you can take a photograph of your application. Next slide, please. Okay, so the application, you'll need to email it back to DTSC at tww_variances@dtsc.ca.gov. And we ask that you put your unique variance application ID number in the subject line of the email. You attach the scanned version of the application with your signature, attach the payment confirmation receipt, and any other information that you're providing as part of your application. Next slide, please. Okay, so that step 5 is now complete. So you're done everything you need to do to apply. So step 6 is essentially DTSC's process of reviewing your application. So next slide, please. Okay, so once we receive your application and we confirm that we've received the reimbursement payment, we will take a look at your responses. We may reach out to you if we need additional information, and we'll confirm receipt of the payment, and then we'll make a decision to grant or deny your request for a variance. Obviously, we anticipate granting the vast majority of these variance requests. The only instance we wouldn't grant it is, for example, if you didn't qualify for some reason. And if your variance application was denied, we would reach out to you and provide an explanation for why that was. Next slide, please. Okay, so if your request for a variance is granted, you will be notified by email, and we'll provide you with a copy of the variance document and also a copy of the CEQA document that the department prepared for the discretionary decision to issue a variance. So CEQA stands for the California Environmental Quality Act. That's a process that department's required to follow when we make discretionary decisions. The last presentation we did last week had some additional information on the CEQA process. So if you'd like to learn more about CEQA, I'd encourage you to look at the presentation slides from the webinar last week. So when you receive your variance, we ask that you read it thoroughly and check it over for accuracy. If there's anything in the variance that you don't understand, please reach out to us and get a clarification. And the variance will be effective on the date that you receive it. Next slide, please. Okay, so just wanted to conclude by indicating some additional sources of information. So obviously, if you go to the department's website, we have that link there is the generic website, but we have specific page for treated wood waste. We have a frequently asked questions section where we plan to continue to update that. So check back frequently to see if there's any updates. We also have a treated wood waste fact sheet, which has a lot of useful information about treated wood. We're going to have the slides from the first webinar, and we're also going to be posting the slides from today's webinar on the website. And then the application page itself has instructions on there too. We also have an e-list that we've created for treated wood waste. So anytime there's a significant news regarding treated wood waste, we're sending out an email to everyone who's signed up on the e-list. And then we also have a email address where you can send questions. It's tww_help@dtsc.ca.gov. I know a lot of people have been emailing that address, and we've been doing our best to keep up with the emails. So, you know, if you do send an email, just please be patient with us. We're trying to get to everyone's email as quickly as we can, but we have gotten a large volume of emails in the last couple of weeks. So with that, that's the conclusion of my presentation.
Thank you, Ryan. Next slide, please. Oh, I'm sorry, Gabby. Yeah, that's fine. So if you'd like to ask a question, please use the Q&A feature at the bottom of your screen. Many of you have done so already, so I'll get started asking some of them on your behalf. So Ryan, transfer stations can also sometimes be a generator of load-checked waste. In this case, would the transfer station also need to complete the generator variance application?
No, so our intent is that you only ever need to have one type of variance to conduct the operations that you want to conduct. So, I mean, I'm assuming the scenario that the question is getting at, it would be, for example, a transfer station that someone brings treated wood to, and they don't find the treated wood until after the person's left, for example. So you can still take that treated wood, and that would be, you know, a covered activity under a transporter variance. So you would not need two different types of variance.
Okay, because there's lots of questions here around whether or not they need multiple variants. If I'm sometimes a generator, but also a handler and a transporter, which variant should I apply for?
So the handler transporter variance covers transportation activity. So, you know, if you're obtaining a handler transporter variance, you would never need to separately obtain a transporter variance unless you were, well, I don't think that would be a common scenario. Some of the variances are more, you know, cover more activities. So the transporter variance is very limited. Essentially, if you're just transporting treated wood from the generator location to the disposal location, that's the purpose of the transporter variance. If you're a transfer facility, obviously the handler transporter variance is what we're sort of, that was developed for your scenario. So our thought is that all of the typical activities that would occur at a transfer facility would be covered by that type of variance. So, I mean, if you're a generator, again, it's intended for somebody that has a fixed location that does some operation that's generating treated wood, such as the agricultural example that we discussed earlier, and it gives you the ability to transport your own waste. So it's essentially giving you that flexibility. However, it doesn't allow you to transport waste generated by others. So I hope that that helps to a little bit answer the question. I know that was a...
I appreciate it, Ryan. There's just a lot of little questions like this. You're just seeking some clarification, so bear with us all, okay? So there's an example of a facility that has an MRF and a landfill, each with its own SWFP. Do they need two variances? The question really being, would the MRF be considered a generator because they recover treated wood waste from the sorting process? Or would the entire facility be covered by a disposal variance since they are ultimately burying the treated wood waste in the landfill? That's a mouthful.
So
did I do okay?
So if you're accepting treated wood for disposal, obviously you need to have a disposal facility variance. So that's hopefully that part is clear. I'm a little bit unclear on the scenario why you would be a transfer facility as well. Like presumably if you're accepting treated wood waste for disposal, you're not going to be sending that waste off site. You'd be managing it, you know, at your own facility. That would be, I think, the common scenario that we anticipated. If there's a unique scenario at a particular facility, we can meet with you and try and figure out how that would fit into this program. But we tried to structure this for, you know, the common situations that we understand treated wood waste would be managed. So, you know, it's very difficult, I think, to try and have a system where one size fits all. But, you know, if you have a special case that's not a typical situation, if you reach out to us, we can try and figure out which type of variance would make the most sense.
Okay, Rizgar, I saw your hand going up.
Yes, thank you, Ali. Just want to clarify the purpose of these variances. We want to make sure that treated wood waste is tracked and managed properly. So if you're a landfill, an example of landfill, and you have a transfer station within your landfill, you just need one variance, because ultimately we know you're processing that waste to be disposed in the right cell or proper management. So you just need one variance from us. You're not required to have two variances. The other example I heard was, if you're a contractor that generates their own waste, you probably will need to have your own either large quantity generator variance or a small quantity generator. However, if you're doing work just to transport others, so you might want to separate the two businesses so that we can have a variance, so you're clear what you generate versus what you do as a contractor where you transport that treated wood waste for others. So you might want to think about getting two different variances, because you don't want to be responsible as a generator for others as well. Thank you.
Thank you, Rizgar. Will transporters, disposal facilities, and ER operators also require maintenance of an EPA ID number in order to obtain a variance from DTSC?
So sorry, could you repeat that again, Ali?
Yes, let me find it. I'm so sorry. I'm so sorry. I have to find it again. Will transporters, disposal facilities, and ER operators also require maintenance of an EPA ID number in order to obtain a variance?
So a disposal facility does require, I believe, transporter, no. And I have to double check how we've written the emergency response variance, but it'll be indicated in the variance itself. So, you know, you can take a look at that variance document, and it'll indicate what the requirements are, and also the questions for each variance type. Obviously, if we're asking for the EPID number, then that's a piece of information that we've determined we need.
I just want to add some clarification there. So EPID number is required as a generator, so that way we identify the waste you generate and the EPID number associated with that. That's for large quantity generator. As a transporter, you're not generating your own waste, so you're not required to have an EPID number unless, as a transporter, you generate your own waste, then you may need to do that. But again, typically it's a generator that is required to have their own EPID numbers. Ryan mentioned landfills may have EPID numbers. Again, Landfills typically, they may get incoming shipment of hazardous waste that wasn't aware of it and they could not find the responsible party. So they will probably, most likely, these landfills will have their own EPA ID numbers for the waste generated at the landfill. So again, depending on the landfill, depends on the scenarios. Typically, however, for the treated wood-waste, that is not an EPA ID number is not necessary. I'm not sure, Rick, do you have additional information you want to add to this?
Sorry, nothing more to add there, Rizgar, you got it.
Okay, thank you both. Okay, so if someone is both a fence contractor and a lumber yard, would they need 2 variances?
I'll go ahead and answer that question. So as a contractor at lumber yard, you may generate your own waste. So again, depending on the type of quantity of waste you generate as a contractor, you may want to get your own variance. However, as a contractor that goes out and does fence mending, fence repairs, or goes out to a farm and removes the fencing for a farm or the poles, then that is a separate. You either need to have your own transporter because you're a transporter of the waste, or you want to make sure that the person that you're doing the work for, they obtain their own generator variance as well.
Thank you. So this is just a technical application question, Ryan. Do we have the ability, or do users have the ability on the online application form to copy and paste from a Word document if they prefer to do so?
That's a good question. I actually don't know the answer to that. It is a Microsoft Forms-based application, so I would imagine that may well be possible, but I haven't tried that myself, so I can't say for certain.
That's fair enough. It's worth giving it a shot. Okay, thank you. So the 10,000 pound threshold is for all hazardous waste generated on site, not just treated wood waste. Isn't that correct?
Yeah, that is my understanding.
Ryan, let me clarify that. Essentially, the assumption built into the treated wood waste alternative management standards was that treated wood was the only waste being generated by those generators. If you have other hazardous waste, there is no lower threshold. So if you're generating any other hazardous waste, setting aside universal waste, but if you're generating any other hazardous waste, you're required to get an ID number for whatever amount you're generating. So if all you're generating is treated wood waste, then 10,000 pounds is the threshold for getting an ID number. But if you're generating any other amount of any other hazardous waste, you should already have an ID number, or you're already obligated to get an ID number.
Okay, thank you. Are we able to run a scenario of a site with multiple locations to determine fees? Do we have that on the slides from last week? Is that correct?
Yeah, so I mean, I can talk generally just to go over the calculation, and it'd probably make more sense after this webinar. If you go onto our website, there'll be a table and it'll actually tell you for, up to a maximum of 10 locations, what the given fee will be. So, we're saying that for purposes of these variances, we're allowing a maximum of 10 locations. So say, for example, you had 12 locations, you would need to apply 2 times, one time for 10 locations and one time for 2 locations. But if you go onto the website and take a look at the table, it will indicate the reimbursement payment based on the number of locations. And just so you're aware, the plan is that information will go live on our website at the conclusion of this webinar, which is scheduled for 2:30. So if you check back after 2:30, that information should be there.
Okay, Ryan, thank you. These are a lot of really great questions. I appreciate the engagement. Someone's opening a new facility within the next few months, and so would need to add that location to their variance. Is that possible, and how would they go about doing so?
That's a really good question. I think if you have a new location and we've already issued a variance, it would make sense to go ahead and apply, again for that new location. Part of the challenge is, so these variances are, they have a 6-month life and the ability to extend them one time for additional 6 months. So if you have a new location, it may benefit you to actually submit a new application, and then you'll get 6 months from the date that that application is approved.
Okay. When will the Class 1 landfill list be updated to reflect the new regulation?
When will so Class 1 landfill, for those that aren't aware, is basically another way of describing a hazardous waste landfill. So there's only 2 hazardous waste landfills in California currently: the Chemical Waste Management Kettleman Hills facility and the Clean Harbors Buttonwillow facility. And only the Clean Harbors Buttonwillow facility is currently authorized to take treated wood in their hazardous waste landfill. So that's part of the challenge currently with treated wood, is that there's only 1 facility, California, that's currently taking it. So that's why we've invited regular municipal type landfills, which commonly would be Class 3 landfills, to apply for a variance. And we opened that up as of Tuesday, and we've so far received approximately 16 landfills have applied for a variance. So that will hopefully provide additional disposal locations throughout the state. But as of today, there's only 1 landfill, which is Clean Harbors Buttonwillow, that can take treated wood. And if anyone is considering taking their treated wood there, I would just advise you that if you take it there, it'll have to be transported by a registered transporter. It'll have to be manifested, and also you should contact that facility in advance if you want to take waste there. You should not just plan to take your waste there and figure it out when you get there. You need to have spoken to them in advance, and my understanding is that they have a pre-approval process. So that's if you want to manage it as a hazardous waste. Another option, which I think most people are probably going to take, is to hold on to it for another couple of weeks until we can get disposal facility variances issued, and then you'll be in a position to take it to a local landfill.
Okay. So just another clarifying question. A small decking contractor who typically transports small quantities of treated wood waste after each job in a covered trailer, would they need to apply for a transporter variance, or just wait for disposal facilities to have their variance?
So you still need, that scenario, you probably will need a transporter variance. Even when the disposal facility variants are issued, what it's giving you, what a transporter variance is giving you, is it's allowing you to transport hazardous waste, so treated wood waste, without the need to use a manifest and without the need to be a registered hazardous waste transporter. So that's what it's allowing you to do, and that's why it's necessary. The disposal facility variance is just their part, which authorizes them to accept the treated wood waste from you. So hopefully that helps explain that.
Thank you. Will the variance tell applicants where they're supposed to take treated wood waste?
No, it won't tell you. It'll just say that you have to take it to an authorized facility. What we're going to do is post on our website all the places that are an authorized facility. So when I say authorized facility, I mean either a transfer facility that has received a variance or a landfill that has received a variance. We're going to post that information online so that if you're looking for a place to take your treated wood waste, you can go on there and determine in advance who is authorized to take it.
Okay. So if you are a commercial generator but do not transport treated wood waste, can you still apply for a variance?
Yes, you can if you want the flexibility. So one thing that a variance does is it gives you additional flexibility regarding storage time. So if you want to take advantage of that flexibility that was in the alternative management standards, and a generator variance may make sense. If you don't want to, if you just want to manage it as a hazardous waste when it's at your facility, that's an option too, and then you would just need to, utilize the services of someone with a variance to transport it on your behalf.
Okay. A question for Deanna and Gabby. We're looking for the fee sheet that we referred to on DTSC's website. If we could share that in the chat, please, that'd be helpful. Thank you. Eric, we'll have that.
Just to point on that, the table that has the reimbursement amounts, it'll be posted the plan is to post it at 2:30. So that's when it'll be available.
Oh, I'm so sorry. I'm causing trouble. I'm not helping at all. I apologize. Thank you, Ryan. Okay, so this question is for Ryan specifically. Your presentation addressed the situation where a highway contractor could apply for a variance for removing items such as fence posts or guardrails. What about railroad contractors performing work that requires handling of old railroad ties? Can this apply?
So yeah, first of all, the ties are hazardous waste. So that would be your first question you're asking yourself. The answer is yes, and you want to manage that in accordance with the alternative management standards, similar approach that existed previously. You would need to get a variance. The alternative would be, if they're hazardous waste and you don't have a variance, you would have to manage them as a hazardous waste. So it sort of depends how you want to, conduct your business.
I just want to clarify again, and I know this answer is probably pretty clear, but we're talking about discarded material that no longer used for intended purpose, right? So if the contractor is shipping railroad ties for use of laying out rail tracks, that is not waste, it's not discarded. So this is only for material that's considered discarded and needed anymore.
Okay, thank you. Some more technical questions here. About how long is it going to take to turn around a variance application?
So the answer is it depends how many requests we get. We're hoping to start issuing disposal facility variances the latter part of next week. Our initial goal was to get some disposal facility variances issued so that there will be additional authorized places to take treated wood. We do have a team of staff that are currently being trained to process these applications when they come in. So we're hoping to process, as many as possible within 2 to 3 weeks of the date of receipt. So, but it does depend on how many actual applications we receive.
Okay, so just to clarify again, a public contractor would never be a generator. Is that true?
Public contractor would never be a generator. So, like I mentioned earlier, there's a concept of cogeneration. So if you are doing work for somebody that results in generation of hazardous waste, you need to have discussed with that person who is going to take on the role of generator for that waste stream. So, I can't answer that. It depends on your what you've determined with your client on how you're going to structure the relationship in terms of who's going to be the generator.
Okay. Would a transporter variance apply to trucking companies?
Yeah, potentially, yes.
If a homeowner is the generator and transporter, oh, it disappeared. As a landfill and transfer facility operator, will we need multiple variances?
So again, I would like to understand more that exact scenario. We have tried to design this program so that one entity shouldn't need to get more than one type of variance. So, I would like to understand the specifics of that more. But if you're a disposal facility, you definitely need to have a disposal facility variance.
Okay, I found the question. If a homeowner is the generator and transporter for 50 pounds or less, will there be a charge at the transfer station?
The homeowner will not need to get a variance from the department. However, the disposal facility may charge you a fee for disposal purposes.
Correct. I mean, it's all dependent on the operator of the transfer facility or solid waste facility. So that's really something outside of our control.
Okay, thank you. Would a garbage company that may haul treated wood waste from a customer select the no physical location on question 18 of the transporter only variances question? Application.
So, I mean, the intent of these variances are for people that are, intentionally managing hazardous waste. I mean, the intent is not that you get a variance on the off chance that someone illegally placed treated wood in their residential garbage. That's not the intent. It's for people that are purposefully managing treated wood waste. So I think the question was geared towards like, should a residential garbage company get a variance as a contingency? And that's really not our intent.
Okay. Okay, can we discuss again for residential projects where the homeowner is considered the generator, what do they need to do as the generator in this case? What application do they need to apply for, if any?
I'll answer that question, Ryan. So again, management of treated wood waste requires you as a generator to obtain a variance from us. The question I think is leading to what if a homeowner transports their own treated wood waste to a landfill for disposal? And the question, one of the requirements for the landfill is to obtain information from the transporter or from the generator, whether they have a variance or not. We are making an exception for the landfills to go ahead and accept that waste, even though the homeowner may not have a variance from this department. They should not reject that waste and just accept it. Again, our intent here is to be protective of California so that homeowner doesn't turn around and takes it home, disposes it illegally on the roadways, or burns it in the backyard. So the intent is to really to manage this hazardous waste properly. So a landfill should accept it, even though a homeowner may not have a variance from GTSC. But as a generator, they're required to get a variance from us.
Okay. As a lumber mill, they generate CAC treated wood waste, but classify the treated wood waste as F035 due to not completing the clean closure requirements. If they complete this process, will the treated wood waste still be considered haz waste since we are treating with CAC?
So, I think the way I would answer that is that this is only for non-RCRA hazardous waste. So if they're talking about a RCRA hazardous waste, that would not be eligible to be covered under a variance.
Yeah, whoever this is needs to contact, if they're under a cleanup order or agreement with DTSC that's managing or overseeing a cleanup of their site, they really need to talk to the project manager about the appropriate classification. There may be other reasons why it's classified as an F035 federal hazardous waste, besides just that it's treated wood. So they really do need to consult with their project manager to get an answer to that question.
Okay. Can we talk about how this differs from federal EPA rules? How our rules are different, why someone couldn't just follow federal EPA regulations on this situation?
Essentially, a short answer is California is more stringent in many respects than the federal EPA requirements, and that ranges from the types of waste that we regulate as hazardous waste, all the way to the types of requirements that are required of California handlers of hazardous waste. But the biggest difference is just the scope of California's hazardous waste program. We regulate many more waste than the federal government does for a number of different criteria of toxicity primarily. So the main difference is that, for instance, in this case, treated wood waste wouldn't necessarily be identified as hazardous waste under the federal program.
Okay, thank you. Okay. This one's a company that's a large generator who utilizes the same wood, same treatment on multiple projects. A transporter drops a bin on each project and then picks up the bin and takes it to the landfill. Their manifest prior to this year was allowed to state, quote, various, as not all project locations were known during the time frame their manifest was in effect. Can they continue to state various locations on the variance, or is the generator required to apply for new variants or possibly update the old one? I hope I captured that question properly. Anonymous, feel free to clarify.
Yeah, I'm a little bit, the reference to manifest, I mean, if this was being managed as a hazardous waste, then that means it wasn't being managed under the alternative management standards previously. So the goal of this program is essentially to, restore the status quo in terms of the way the alternative management standards operated previously. And if you look at the variance documents, the language is very similar to the language that was in Chapter 34 alternative management standards. So if you were operating under consistent with the AMS standards, and the program is intended to operate in a similar way. So, without knowing more specific information, I can't really provide a more detailed answer.
Okay. Feel free to clarify, Anonymous, if you want to submit another question. I'll do my best to catch it. If a contractor removes guardrail posts from a job site as part of a project, is the contractor considered a generator, or is the owner of the generator, or is this an example of co-generators?
So that would be a co-generator example where you need to establish that with whoever you're doing the work on behalf of. So, I think in many cases, whoever owned the wood, prior would be considered the generator. I think that's a common way that it's interpreted. So, if the, say if it's a county, for example, if it's a county-owned roadway, if the county is agreeing to be the generator, then the contractor doing that work would just require a transporter variance.
Okay. Can we talk about why California is attaching a fee associated with the disposal? Maybe I'm not sure if it's the fee associated with disposal or application. Can we talk about the fees associated with the application and why those have been imposed?
Sure. So it's actually a reimbursement. I mean, so when we issue a variance, the statute that we operate under requires that we recover our costs for issuing variances. So we don't have the option to do it for free. And the reimbursement payment that we've come up with is based on our actual costs to date and our anticipated costs to process these variance applications. And we have documentation that we're happy to make available if you'd like to see the assumptions that go into that. We've established a fixed reimbursement payment amount because we're anticipating issuing a large number of variances, and they're all very similar, so the level of review is comparable. The alternative would be to enter into a individual reimbursement agreement with every applicant, which we could do, but would be very labor intensive and would probably end up costing more and delay the process of issuing variances. So just to kind of summarize, we're required to recover our costs by statute, and the payment amount is based on our expected cost to process and issue the variance.
Thank you, Ryan. Does the amount of treated wood waste that someone generates need to be taken into account in determining whether they are an LQG of hazardous waste and subject to those requirements?
Yes.
Okay.
Essentially, the only type of waste that is authorized by our statute and regulations to not be counted towards your total generator status is universal waste. All other waste, all other hazardous waste anyone generates is calculated into the generator size qualification.
Okay, thank you. Give me just a moment. Thank you for your patience. Is there a difference between EPA ID number and a Cal EPA ID number, or do we intend those to mean the same thing for the purpose of this application?
You go through the same process to apply for a number. An EPA ID number, technically speaking, applies to those who generate federally regulated hazardous waste, whereas a state ID number essentially is for those who generate state-only hazardous waste. So if all you're generating is treated wood waste, no other federally identified or regulated wastes, then it would be a state ID number. But again, you would come to DTSC to apply for that number, and you would be kind of channeled through the right process depending on the type of waste you're generating.
Okay. In which circumstances would a variance application be denied? Does DTSC have limited number of permits that we will be issuing per each variance category?
So, I mean, one scenario we would deny an application is if you just didn't qualify for some reason. Again, we don't anticipate denying a lot of applications. And, if someone was to have applied for the wrong type of application and we catch that, we'll try and work with you, and we may be able to apply, transfer it to a different type of application. So, we don't anticipate denying a lot of applications, and it would only be in the scenario where you didn't qualify or weren't eligible for a variance.
Okay.
And there's no limit to the number of variances the department could issue.
Thank you both. How would you address the variance application for an agency which has hired a contractor to construct a linear transportation project, and part of the contractor's work requires removal and disposal of treated wood waste? The quantity of treated wood waste would be characterized as large generator, but the agency is not in the business of generated treated wood waste in the long term and will not self-transport. Will there be multiple variances required in this situation?
It sounds like the situation of another cogeneration, right? So, I mean, it's either the owner or operator of this project or the contractor that they've hired could, in fact, take on the responsibility for the management of the treated wood waste and apply for and receive the variance. But, ultimately, at the end of the day, one of them has to. So if it is ultimately the owner of the project, and they cannot secure the commitment of the contractor to do that, they're going to have to take on that responsibility themselves.
Okay, thank you, Rick. And thanks for hanging in there. It was a mouthful. It sounds like a contractor essentially just needs to obtain one variance, small or large, depending on the total amount of waste they generate every 6 months. Would that cover multiple job addresses, or is one required for each address?
So, I mean, just to clarify, the 10,000 pounds is per calendar year. So, just to clarify that point. I mean, if you're a contractor but you're never a generator, you can get by with just a transporter variance. It really depends on how you structure your relationship with your client and who is the generator. So, I can't answer that not knowing the specific situation. But yeah, again, if you're not the generator and you're a contractor, you could just apply for a transporter variance, and that would allow you to transport from any job site. It wouldn't matter if it was, multiple different job sites in different locations.
Okay, And I know that we've answered a lot of these questions, and so there's lots of clarifying questions because this is a complicated subject. So Rizgar stated once that some applicants will only need one variance, but said another time that some may need 2 variances. Can you please clarify whether some applicants will need 2 variances and maybe under which circumstances that might be?
Sure. I'll give you an example of this. So we've been communicating with Caltrans, for example, and Caltrans has they have new projects where they generate waste from the new products, and they have also within the same region they have a operation and maintenance facility that generates their own waste. So in discussion with them, Caltrans for that region will be receiving, if they apply, 2 variances. That's an example. That's a large example. However, the example of co-generators. So if you have a contractor and you generate your own waste as a contractor, because you may have a lot of clients, so you may want to have your own variance because the contract with that particular generator, you are the responsible party for that as a generator. So you may want to get a variance for that. And however, some generators may not want to do that. So again, that's depending on the relationship you have with that generator. So again, there's a lot of variances to that question. Again, it's a specific question and specific answers to that question. There may be more than one variance you may need. That's correct.
Yeah, and if I could just add to that, Rizgar, if you're doing 2 types of things that are completely different, it's possible you might need 2 variances. But if you're essentially engaged in one activity, then we tried to design this so that could be covered by a single variance. But if you're doing 2 different things that are essentially unrelated and completely different, you may need to get more than one type of variance. So if you find yourself in that situation, if you want to reach out to us, we can try and have a discussion and figure out what makes the most sense, because I wouldn't want someone to apply more than once if that was unnecessary. So if you're not sure, you can reach out to us. You could send an email to tww_help and ask us to give you a call, and we'll be happy to do that. Obviously, we're getting a lot of questions, but we'll do our best to get back to you, and we can talk over the specific situation and try and figure out what makes the most sense.
Thank you, Ryan and Rizgar. So just to clarify, a transfer station that is also owned by a landfill only needs 1 treated wood waste variance for a disposal facility. Is that true?
So again, this goes back to the question, is that transfer station at the same location as the landfill? So for that scenario, yes. However, if you have a landfill with many transfer stations and that Ryan talked about, a particular variance could have up to 10 locations. So that could be one variance with different locations, and the fees for that variance application would be a little different because you have 10 locations now. So again, depending on the scenario. However, just to answer your question clearly about if you have a transfer station within the landfill location, you just need 1 variance.
Yeah, I would agree with that, Rizgar. Yeah, as long as it's part of the same facility, and any treated wood waste that's coming into the transfer station is ultimately being disposed of at that same landfill, I would agree that would be a disposal variance situation.
So the logic behind it, we want to have an accounting of all the treated waste that's being disposed in California and make sure it gets managed properly. So this is more to us, more protection and making sure the waste doesn't get disposed improperly.
Thank you. So this person operates a transfer station as well as being a refuse hauler. Will the handler transporter variance qualify for both materials disposed of at the transfer station and hauling materials generated from a residential or commercial address to the transfer station?
You just need 1 variance.
Yeah, as long as you're transporting to or from that transfer station, that would all be covered under a handler transporter variance.
Thank you. We appreciate that you will update your website as landfills are authorized to accept treated wood. Would you also coordinate with CalRecycle and the State Water Resources Control Board to make sure they replicate this and maintain updated lists, as this is important for the public to know the proper facilities in their area?
Sure, we could definitely notify them. We're in close communication with CalRecycle. We can notify them of the approved landfills.
Thank you. And thank you, Kathy, for the question. Okay. Treated wood waste that was collected during, is that January 1st to March 1st in an approved AMS container that was illegally disposed of at a Class 3 landfill that needs to be disposed of, may be buried at the Class 3 landfill once they receive the variance, or should it be hauled off?
So I want to make sure I capture this question correctly. So a treated wood waste was collected and disposed illegally now because it needs to be managed as hazardous waste, so at Class 3 landfill. The question you're asking whether we required them to bury that material, and I think that's a good question. And I think what the best to do is communicate with our enforcement group so we are aware of the details of the circumstances around illegal disposal. And potentially we could refer to CalRecycle as well. But again, this is something that needs more than just a quick response.
I appreciate that, Rizgar. Thank you. May I burn treated wood that I have determined to not be hazardous through knowledge of process generating the product?
Technically, we have no rules against it, but I would advise against it. Essentially, even if it doesn't have sufficient toxic metals that cause it to be a hazardous waste, it's still going to have toxic metals. It's going to have arsenic, it's going to have copper, it's going to have other things in it which are not healthy to put into the atmosphere or to breathe. So again, can we stop it? Do we have rules and regulations to prevent it? No, but again, definitely unadvisable.
For your own safety.
For your own safety, and exactly.
Thank you, Rick and Rizgar. Can you provide more information on the role of the training coordinator and reporting requirements?
Sure. So the training requirements that we're going to be writing into these variances are the same training requirements that existed in the alternative management standards. And there's specific language in there about what the training should encompass, but a lot of it is fairly straightforward in terms of making your employees aware of the hazards associated with treated wood. Also, in the case of a variance, one element of training would be, informing your employees of what the variance requires. So training on how to comply with the terms of the variance, and, could include, anything related to appropriate PPE or appropriate storage requirements. It really depends exactly what your operation is, but it is an important part of the program, and we're just replicating the same training requirements that existed previously. What was the second part of the question?
I have to look for it. I'm so sorry.
We're looking for it. Again, treated wood waste is hazardous waste. Again, it needs to be managed with special care, and under the alternative management standards, there's some training requirements for the employer, for the generator, and again, it's crucial that you follow the requirements and understand how you properly manage treated wood waste. Is it something that should be taken lightly? That's why Rick mentioned you should not burn it just because it's okay to burn it. There is a risk associated with burning treated wood waste.
Okay, this one, it's possible this may be our last one, but we're going to take as many as we can before the end of our time here today. This person's on a military base where they performed a one-time project tearing down and rebuilding fences. They didn't complete the project until after this new regulation passed, and so now they have an excessive amount, which is over 50 pounds, of treated wood waste, in which it is unfeasible to store it properly without transporting it somewhere first. Can you please confirm that they are not legally able to transport these materials to a better place without a variance?
That's correct. Federal government does not get an exception from proper management of treated wood waste.
Thank you. Okay. Just a moment. We have time for one more. Okay. Is there a way to modify the variance to add more locations, assuming you don't apply with all 10 locations at time of application, or do you need to apply for another variance if new locations are needed? I think you guys answered that earlier. So if someone doesn't apply, is there a way to modify the variance to add more locations should they need to after they originally apply for
Right. So
the
I
variance?
want to go back to the notion when the fees we collect part of the process. It's that we review that particular application, and there's a review of the CEQA requirements, and that's done per location. So again, if you resubmit another location, the whole process starts over again for us. Again, we need to review the previous application that was submitted and the new location. So the workload associated with that will be about the same as the first variance. So, so to answer that question, it'd be a new application and new fees applied to that. Because the amount of time it takes our staff to process that will be about the same.
Okay, thank you, Rizgar. And Deanna, would you like to give an update on the pending legislation?
Yeah, so just, I know there's a couple questions through the chat. And again, the Vasquez by Esteros legislature for the department. So we are currently working with the author's office on AB 332. That's really trying to figure out more of a long-term solution. So I know there has been a lot of questions regarding why is a 6 months variance and then additional extension for 6 months. This is something that both the Senate, the Assembly, and the governor's office is clearly aware that we do want to provide a long-term solution. So this is something that we're working on collectively and seeing if we can actually expedite the long-term permanent solution in the next couple of months. So that's something that I can say, you know, anything can happen, obviously, but one of the things that all of us are in agreement that something has to be finalized, and that has to be in place before we obviously end the different variants at the end of this year. With that said, we will be providing updates. That will be really critical for y'all to be a part of the EAT list. So we're going to be providing updates through that channel. So if there's any questions or concerns regarding the process of the legislation, we will be able to communicate with you through that means. Okay.
That's very helpful. Thank you so much, Deanna. Thank you, Rizgar, Ryan, Rick, Matt, and Deanna, Gabby, Rob, for all of your help in getting this information out. And thank you all for joining us today and for your thoughtful questions. I wish I could have gotten to all of them, but again, we will continue to use this information to update our frequently asked questions on the website. And for now, I wish you a fantastic afternoon. Thank you.